Good afternoon, everybody. I hope you are not falling asleep after lunch. It's a good lunch. Let us start the session now. I think we're going to start the session about social values, which we have been discussing since this morning as a very important but challenging topic in the context of valuations. So I'd like to invite three presenters. First of all, Ben Elder. He's the Global Director of Valuation at RICS, who is connecting online, I guess. Ben?
Hello, Satoshi.
Hello, good afternoon, good morning to you.
Good morning.
So
for my shirt, special shirt.
Yeah, batik. Excellent.
Yeah, absolutely.
Okay, very good.
A bit scary. I look a bit big behind you, Satoshi. But
yeah, it's a bit difficult to see you. But anyway, that's okay. So thank you very much, Ben. So floor is yours.
Thank you, Satoshi, and good afternoon, everybody. It's a great honor to be with you. I'm sorry I can't actually be in the room. I'm wearing this shirt which MAPPI kindly gave me on one of my many visits to Jakarta, so thank you and best wishes to everyone in the hall, old friends and new ones. I've got about 15 minutes to run through some important issues, so if you could move to the next slide, please. And what I want to look at is the manual for the valuation of unregistered land, and that there are two key messages which I would like to just start with, and then we'll run through the slides to reinforce those. First message is that markets existed a long time before registration. So markets operated before registration. So registration is not a prerequisite for a market and a market value to be calculated. And that's a really important message. The second message is that valuation is a process, and we'll look at the International Valuation Standards and how those provide a legitimate framework for the process of carrying out evaluation, and it provides both the valuer and the client with that assurance, that legality in following a framework which is recognized globally, and remembering that much of the evidence which we produce as valuers will be audited at some point, and again, particularly if it goes into a infrastructure loan, it will probably be audited several times, and providing that explanation about how the valuation has been arrived at is critical. Next slide, please. And it was with those two key points in mind that I had the privilege of working with a small group to develop the manual for the valuation of unregistered land. But this work has been going on for many, many years. It's built off the United Nations Sustainability Goals, and next slide, please. Also lots of other documents which have been produced by various organizations, including the United Nations, including FIG, RICS, UN Habitat, GLTN, and there's a myriad of documents which exist to support this process. But what we wanted to do with the valuation of unregistered land was to provide exactly that, a manual, so that individual valuers who were being asked to value land which was not registered had a procedure, a process to follow. Next slide, please. And this was built off the premise that the International Valuation Standards were in existence, and the challenge was that in the style that the International Valuation Standards had been written prior to 2022, they read as if they were really only for urban development. And that wasn't true, but they could easily be interpreted in that way. And in the 2022 edition, so this is not the latest edition, but the one before that, we managed to get some significant changes made so that the core principles of valuations could apply to a wider range of real estate and land. And what we were able to do was to get into those standards a recognition that value may be held in informal tenures, and that opened up the legitimacy of the international valuation standards to the valuation of unregistered land. Before that, it always talked about leases and formal arrangements. And as we all know, much of the world is held, and that this change allowed the unregistered land to be embraced by the international valuation standards, and as it says on that slide, legitimize the legal and regulatory frameworks which sit around the valuation of unregistered land, and provide, absolutely critically, a consistent approach in adopting the framework. So it produces that framework within which the valuer can operate. And there's an important note at the bottom of that slide as well, where it says valuers are not policymakers. Valuers are good at doing their work as valuers, and that's their key role, but they're not there to make policy. They're there to apply the policy which is made by others, and again, that's a really critical element to have. So, for example, the data valuation. Now, that's probably laid down in the legislation at some point regarding compulsory purchase, but I've seen many a debate about what is the data valuation, and particularly if the valuation has been done at some point in the past, and perhaps there's been some high inflation in the relevant country over the preceding years, and now the number which is being calculated is no longer sufficient to allow the person who's had their assets taken to replace them. So again, dates of valuation being being able to update valuers or valuations is all key part of the manual, and it leads the valuer and the client through the process. Next slide, please. So I would certainly encourage anybody who's operating in this area to look at the international standards and then look at the manual. That slide just reiterates the changes which were made in 2022 regarding the incorporation of unregistered land into the international valuation standards. And next slide, please. What this shows, this slide, is that carrying out a valuation is a process. You go through various steps, and that's how the international valuation standards are structured. So what you do is you agree your scope of works, your terms of reference. You agree the basis of value, and we'll come back to that in a moment about the difference, particularly between market value and investment value. So market value or worth. And who that worth is to. So we get the scope of works, excuse me, we agree the basis of value. We then agree our valuation approach and what method we are going to apply to the valuation. We then collect the data and the inputs, and then we apply that data and inputs into the valuation model, and that then creates the documentation and reporting, and then we've got some particular asset standards which support those other processes. But it's carrying out that process of getting your instructions, capturing the data from the marketplace, applying it to a recognized model, and generating a report. And your report should cover everything which is in your terms of reference. And so it creates that virtuous circle of quality assurance in the process. And it tells a story. It allows the valuer to tell the story about what they've been asked to do in their valuation. And that provides that legitimacy, which is defendable by the valuer and their client at some date in the future. Next slide, please. The process of valuing unregistered land is again really quite an interesting one, and it basically is triggered by an economic concept. And I believe in the previous session this morning, Nicholas was doing the moderating, and I spent many hours talking to Nicholas about this concept of economics and how everything that gets constructed actually uses, and putting it right back to real basics, that anything that is constructed actually uses energy. You need energy, you need food to actually drive the body to make the changes in the land. And therefore, at every point, there's this decision about is it worth doing that work? Am I going to get a bigger return from the work I'm going to do to pay for the food which I've had to use the energy to build the building that we've had? And you very often see across countrysides very strange buildings in what appear to be very strange places. But if you do your if you do some investigation, you'll usually find there's an economic concept. And if it's not an economic concept, then maybe it's actually a religious concept or other concept which sits outside of economics. And therefore, though we're starting to look at some of the social value which might be captured in different methods. But the economic concepts we approach through the market approach, the income approach, and the cost approach, which will all be very familiar to the audience there today. Within those concepts, those economic concepts, we also use quite challenging definitions, particularly around if it's a business, a reasonably efficient operator. We also have the concept of modern equivalence, where a building perhaps is constructed to different standards than would be prevailed to today. And then we also have this concept of equivalent benefit. So is something going to provide the same benefits as previously held, but in a different format? And those concepts sit alongside those three approaches to valuation. And then the safeguard standard 5 from the World Bank, and I know that the ADB and other providers of funds for particularly large infrastructure projects have this concept of encouraging negotiated settlements. So rather than going to the formal side, the starting point is the negotiated settlement. But also you have to remember that within this negotiation there's the recipient, but there's also the taxpayer, and the taxpayer should be not disadvantaged by the process either. Next slide, please. If we look at the actual manual, it runs through definition of market value. So that is, you can capture that from the market. May be more difficult than finding the evidence that exists when land is registered, and finding out who actually gets the benefit from the land can be quite challenging. But doesn't mean to say that it cannot be done, but there's more risk involved. And if there's more risk involved, then that risk is reflected in the valuation, because people, organizations reduce the amount of they're prepared to pay for a piece of land, for example, a farm, as the risk increases. If it's become more risky for them to continue to receive the benefits from that piece of land, then they pay less for it, and that's the whole concept of land and unregistered and registered processes. So the process of registering, in general, in most cases, reduces risk, but not in all cases. And if we can move to the next slide, please. Again, looking at that, the concept of value, and looking at methods that we approach with economic value, and then the social and cultural values, ecological values, and plurality of values, an economic and accounting term which may be significantly different from market value. So we need to look at these overall concepts. The valuer may need to bring in additional skill sets to help to assess those social, cultural values and ecological values. We're very good at the market values, but once we start to get externalities which sit at the outside of market transactions, be they registered or unregistered, then we start to get into some really challenging areas. But the value is a key part of that. I'm not trying to undersell the skill sets of valuers. We have some really key skills in there, but what the manual helps you to do is to articulate when you're operating in that economic zone, but then also when you're starting to operate in the social cultural values hemisphere, and ecological values as well. And it provides that framework about telling that story of how you are capturing and reporting those values. Next slide, please. So what we want to look at is methods of estimating non-market value. So we're now starting to look at those values which are sitting outside of the normal marketplace, and these are revealed in transfer, exchanges, leases, licenses, etc. So what is actually assessing the willingness to pay? Is there some process that can be captured to identify if these are not market considerations, but if they were, how much would parties be willing to pay for the retention of a particular feature for an asset? And we look at those different metrics and how we can reduce risk and uncertainty in the holding of those assets. And next slide, please. And we're coming towards the last couple of slides you'll be pleased to hear. But this slide actually looks at the difference between market value, which show, sorry, if we could go back to the one with the squares on, please, that would be great. There we are. Thank you. Market value. The first four squares identify the process for collecting information around unregistered land, determining existing markets, and quantifying market value. So that's the traditional way of dealing with market value. But then if we start to look at investment value, that is looking at worth to the individuals or to society, then we need to start to look at identifying any non-market values and then qualifying those processes into the summation and the story that we're telling. And again, the manual for the valuation of unregistered unregistered land helps you to look at how that might be achieved in the case of unregistered land. And next slide, please. This next slide just runs you through the principal parts of the manual and helps you to identify the processes. So the key parts, there's a glossary of terms, which is really important because it helps to really define the process, gives an overview of valuation related recommendations. So how do you go about collecting the evidence that you might need for completing your valuation? Recommended practices for valuing unregistered land. So how do you capture, how do you identify who the beneficiaries are, etc. It also then talks about the purpose of the practice manual and provides you critically with some templates for the valuation of unregistered land rights. There are some case studies and I know that we're going to see some case studies later on in this presentation which will be hopefully bring some of these concepts to life for you. And then also some narrative around due diligence questions, particularly around customary land holdings. So it's a very practical document, and I would recommend that that anybody who's undertaking the valuation of unregistered land consults with that document, because it does provide this framework of legitimacy that is important not only to the valuer to protect the valuer, but also to the clients to be able to for them to be able to understand. And that concludes my presentation. Next slide just gives my email address, etc. If you wanted to reach out, I'd be happy to hear from you. But Satoshi, that was a quick canter through the main points of the valuation of unregistered land, a practice manual, and it is freely available on the website by clicking on the link on the bottom of the last slide. Back to you, Satoshi.
Thanks, Sven. It's very interesting presentations. I have heard of this presentation several times, but it's always very interesting to hear with some new findings or discoveries. Now we move. Now we invite two more presenters. Please come to Nick Llewellyn Jones. He is a principal and head of the Native Land, Native Titles, Resource and Renewable Energy team at the Norman Waterhouse Lawyers. And also Franklin, would you be able to come along also? So that we don't need to invite you each time on the front. Okay, Franklin Odun, I'm sorry, I couldn't pronounce your name very clearly. He's a tenure professor, Faculty of Social Science, Global Development Studies of University of Helsinki. I think it is your presentation, right?
Yeah, I think so.
Yeah, so please put out Nick's presentation. Yeah, I think this is the one, but need to go back to the first presentation, first slide. Here we go. No.
All right. Look, thank you for having me. Satoshi, you're happy for me to start?
Yeah, please.
I've provided more slides today than what I intend to talk to because I believe they'll be available afterwards. There's some technical material in the slides. But by way of context, I'm not a valuer. I'm an economist and I'm a lawyer, which I'm happy to sort of talk through. But I was asked to come today to discuss the Australian context of dealing with unregistered land because we have quite a detailed historical system in place in Australia to deal with our Indigenous populations in Australia, Aboriginal people. And so I'm here to talk about that. But having listened to Ben a moment ago, I think it's important to recognise two fundamental difficulties for valuing unregistered land, especially when we're dealing with unregistered interests of Indigenous populations around the globe. The first one is that there is insufficient data. We talk about market price, market data. There's obviously transactions taking place for registered property all the time, but with unregistered property interests, there's often not that level of data. The second issue which is there is if we talk about equivalent benefit, which from an economics perspective, I think about from indifference curves. This is how we think about it, utility. You get utility, you exchange utility. Market price that is used in valuations. Every country in the world uses some version of the market value test. It's based on an assumption that something is equivalent somewhere else. So if you spend $1 million in Jakarta versus $1 million in Singapore, the exchange is equivalent, or Kuala Lumpur to Malacca, the exchange is equivalent. But for most Indigenous communities, they have greater utility for the land in their traditional countries, or their traditional regions, their traditional villages, or whatever it may be, depending on the anthropology of each group. And so the entire notion of indifference curves between market price breaks down to some extent when you're dealing with Indigenous interests, because what you've got is a situation where most Indigenous people that I know, having represented a lot of Aboriginal people in Australia over the years, would not value land outside the traditional countries equivalent to land in their traditional countries. And so all of a sudden the entire notion of equivalent benefit, or what economists call utility or indifference, breaks down. So these are big challenges: a lack of data and the fact that some of the economic assumptions don't work. In line with that is another point I'll make with Ben. And as I said, look, I'm not going to go through all my slides today. I've provided them as a reference for people if you're interested. It's this notion of externality. And so one of the challenges also that applies with unregistered interests is that if there's a market equilibrium which doesn't bring these interests into account, then what will happen is the market outcome will not be socially optimal. This is again the economist speaking. So the work of people like Ben and the work of organisations and guidelines and protocols that have been developed is really important, because without those, you're going to end up with equilibria which are not consistent with what's beneficial to the economy overall, and in some ways are distorted. They're distorted through all these negative externalities. So we do need to tackle this problem, notwithstanding the fact that there are very difficult root causes as to why it's so hard to deal with. Again, a lack of data and this assumption of indifference which doesn't, or utility which doesn't bear out. In Australia, we have a native title system. I'm one of the leading lawyers in Australia for that system, at least recognised by my peers. That's not a statement I make about myself, but I've been privileged to be recorded as such by other lawyers in the field, which I appreciate. And our system in Australia is that large parts of Australia, and you can see the part of Australia covered by green on that map, are covered by native title determinations, which means there are certain property rights for Aboriginal people in varying degrees for those native title holders. Those interests, by and large, are not recorded on our torrent title system. They're not recorded in the way that other property interests are recorded, which is really problematic, but nonetheless they're protected by law. As a consequence of this system, we've adopted a slightly different model in Australia. We have compulsory acquisitions and we do have litigation over how to value native title, and this is a very complicated issue. But we have firstly developed a negotiation-based model, and that reflects that lack of data. So in Australia, what we have done in our legal regime is to create a system of claims. Those claims go to a court structure, a process, they get determined. There's a corporation set up to represent the Aboriginal groups that they are all entitled to be members of once they're determined. And then that organisation goes into a negotiation model with any entity which wants to engage in development on native title land in Australia. There are obviously some major downsides to this model. One is that there's massive degrees of different capacity. largest multinational corporations in the world, often negotiating against very remote communities. This is obviously a difficult dynamic. There are benefits to this model, though, and one of them is that it removes that massive problem of the lack of data and this issue of how do you bring in these other social factors or these other indifference factors into valuation, because you have a framework which sets out, well, what the negotiations will be for those property interests. In Australia, every year, about 50 to 70 large agreements are done between our Indigenous populations and miners, renewable energy farms, port developers, etc., etc. And that's becoming even larger now that there's more growth in renewable energy. And it's a really interesting issue about competing land use in Australia, as I'm sure is happening everywhere globally, as we transition towards renewable energy, which often has a larger land footprint, a lower ecological footprint, but a larger land footprint. This isn't limited just to Indigenous communities. This is a native vegetation issue in Australia, as I'm sure it is elsewhere, but it's becoming more and more prevalent. As part of that, I've been privileged to do maybe 20% of all of those negotiations in Australia in the last 5 years, so we're very much on top of this area, my team and I. In fact, we've won a couple of Premier's Energy Awards. I don't want to go into the negotiation outcomes in massive detail, but I will give an indication of what has happened successfully in some cases. For example, one group that we've been working with ended up the shareholders of the largest solar farm in their traditional lands. They ended up with about $80 million as a benefit for 1,000 hectares of native title land, which was converted over to, in fact, it was registered. The unregistered interest became registered. They became the landowners of it. And then now, as Aboriginal people, large part owners, about 15% shareholdership and landlord of the largest solar farm in the traditional country, so that's a good example. Won a Premier's Energy Award for that. Other issues, of course, to deal with heritage and power lines. You know, this is getting a little bit off topic, but there's been examples of that as we deal with infrastructure corridors and land, and you know, there's been these very positive negotiation outcomes. So I do want to say that the negotiation model that we've used in Australia has achieved some good outcomes. Another example for port infrastructure was part ownership of a port development by a local Aboriginal group. So there can be good outcomes. The reverse of that is also true, though, and I'll be honest about it. There are often examples of agreements being done where the benefits are very, very low. This actually, just to say an interesting aside, this is one we did last year for the first ever desalination agreement for a desalination plant involving Aboriginal people in Australia. And I raise this because, in fact, as part of the growth towards renewable energy, the need for water is more and more prevalent. So these are issues which have come from our system. So having a legal structure with a negotiation model in Australia has provided some good outcomes. It hasn't, however, dealt with the problem of valuation. Having now conducted probably 15 to 20% of all negotiations in this space in Australia in the last 5 years, I can tell you that the price divergence between the companies and the Aboriginal groups are very dramatic. On average, the first offer is about 1/10 of what we settle on. And that's not a criticism of either party. This is the fact that we are dealing with a situation where value is very different. Firstly, market value is often based on very limited data from previous land sales which are not connected to the area. We are talking about some of the most remote areas of Australia. Second of all, the investment value is significantly different to what might be the prior value of the market sales. And a good example of that has always been in Australia, pastoral properties which might be near electrical infrastructure. You can have two almost identical pastoral properties in Australia. I know this is a little bit different in Indonesia in terms of, I'm using an Australian example, so please, my apologies for that. But one of those pastoral properties can be right next to an electrical substation, which means for a solar farm or a wind farm, that property is worth $10 million more, Australian dollars more, than say an equivalent one only 8 kilometres down the road, because that infrastructure is so valuable. And so we have all these fluctuations in value as we change land use with developments as well. And then we have the difficulties I said before, which is native title groups, especially in circumstances where they have a stronger bargaining position. We'll talk about compulsory acquisition later. There are circumstances where, particularly with mining in Australia, Aboriginal people do not get a say. They can be overridden through compulsory acquisition. But in terms of other projects, there can often be a very big difference between what a traditional group might value its property as and what other people might because of spiritual significance or historical significance. And these factors mean that there are major problems. So if you look at this as an example of price data in Australia from the last 5 years rather of negotiations, and then you say, well, how do you as valuers try to apply a process to create this without that data? I think it's a really difficult task. We do try to do it in Australia, but I take my hats off to all of you for embarking in a journey to try and work your way through a process of doing it, and I congratulate people for developing processes to do it, because this is a very formidable task. The difficulty being that if it's not done, then a very important sector of society misses out on important benefits as we transition economies in different ways. We have, as I said, compulsory acquisition in Australia, and what we do in Australia as best we can when we're not negotiating, when there's just a formal valuation process being done, is we try to convert the traditional unregistered interests, which for the Indigenous groups might involve the ability to use the land or hunt traditional flora and fauna or wildlife. We try to convert that into what that would be equivalently for freehold, for Torrens title system. What's the kind of percentage that we would give? And as a general rule of thumb, we say it's about 50%. The traditional interests represent about 50% of owning the land in fee simple. That's generally what we do in Australia. And then we give a loading to recognise that higher utility. We call it solatium or cultural loss, but it's effectively a loading to say that there's a cultural or spiritual connection. And so we end up doing that. But the issue of that loading, the loading that we provide, is really, really complicated. So we will take the best use value of the land, we'll convert the land, we'll say what are the Aboriginal interests in the land, we'll convert it to a percentage as if it were freehold or traditional property interests. We will only take the land value, not the alteration value, and then we'll give a loading to represent cultural loss or solatium or a spiritual connection, with that loading being a very difficult question to calculate. But that's the method we use in compulsory acquisitions in Australia when we do not have a bargaining model, when things break down and it ends up in court. I'm not an expert in Indonesian law, so I don't intend to talk about it, but I do note that there are some parallels as well as significant differences in native title to the Dutch system, and I understand it's a very controversial and complicated issue in Indonesia. I just wanted to recognise that these are challenges we all have in different ways. So although I'm coming in as an Australian with a knowledge of Australian law, it's actually been a real privilege for me to do a few of these conferences recently around the world, including one in Africa, or involving in Perth rather, but involving the African government of Kenya in Perth, and thinking about how the fact that the challenges that the Indigenous Australians and the lawyers representing them and working in that sphere have had to deal with in working on value is a problem that exists in all parts of the world, whether it be Indonesia, parts of Africa. It really does, in fact, come down to value. I mean, let's be blunt about it. We can create this entire model, but if the Indigenous people of Australia, or for that matter, unregistered property holders elsewhere, end up missing out on appropriate compensation if they lose their property rights, whether registered or not, if their life is made worse off or not made better off, then that is not a good outcome from a social equilibrium perspective. And that's really, at its core, a question of value. We can frame it however we want, but actually what people get in exchange for something at its core intrinsic level is what defines fairness and justice and these kind of more aspirational concepts as we transition the economy. So it's really difficult because we end up with these great ideals which get distilled into an accounting methodology which is really, really difficult for people to apply when there's no data. Look, again, it's been a privilege to be here, and I hope that by talking about the Australian model very briefly, if nothing else, I can exchange the fact that we struggle with this too. We have real difficulties with these challenges too. In a practical level, I've spent the last 5 to 7 years, well, I've spent 20 years doing native title, but particularly the last 5, 7, 10 years as the renewable energy industry's taken off in Australia, thinking about how does this work in terms of traditional land rights in Australia? What is a fair value? What is a means of exchanging these development approvals and loss of land, loss of utility with an appropriate financial compensation for this. And it's been a real challenge in Australia. It's been a real privileged to see the challenges that are being faced everywhere around the world with exactly these issues. And I could talk about the Australian system for the next 4 hours, so I'm not going to do that. Hopefully my slides are useful. I do have a technical schedule at the end of the slides for people who are more economically minded to look at. But if I can conclude on that note, I'd just like to say that I think we have to juggle these challenges together, and I think it'll be an iterative process. I think we will, by that I mean, I think we will come up with a solution and we'll see how it works in practice, and then we'll continue to improve it. And I suspect it will take a decade as we continue to improve our processes to try and deal with these traditional interests. But I've greatly enjoyed the work in doing it, and I hope that this has been helpful today for everybody here. So thank you.
Thanks, Nick. Very useful, interesting. Particularly, there's lots of recent development in Australia. So now, Franklin, please put up his presentation now. He's going to talk about experiences in Africa. Just bear with us until his presentation is put up. Okay, here we go.
Okay. Colleagues, it's widely claimed that the registration of land title enhances valuation, that what requires further reflection is whether, for the purpose of compulsory acquisition, title registration is prerequisite for valuing unregistered land. How is the valuation of unregistered land done in practice? What challenges arise in the process? And what can be done? These are core valuation questions, particularly in many parts of Asia, Africa, and South America, where unregistered land can constitute more than 50% of all land to be valued. These questions are also quite central to political economy. Those who live on such land tend to be the most marginalized people. As we've just heard, indigenous people, descendants of slaves, religious and gendered minorities. In his stimulating book, Legal Foundations of Capitalism, J.R. Commons notes, and I quote, "The concept of value on which economic as well as legal theory turns is a synthesis of all these," unquote. Such is the pressing nature of these questions that, with funding from the RICS, Professor Spike Boydell, Dr. Mike McDermott, and I attempted to address these questions. Most mainstream economists see the need to distinguish between use value and exchange value, but they prioritize highest and best use, market value, and the creation of land markets. In this framework, unregistered land is anathema. The economist calls it no man's land. Hernando de Soto, that eminent Peruvian economist, calls it dead capital, and many World Bank economists concur. In this terra nullius economics, unregistered land is a barrier to valuation. To overcome it, agencies like the World Bank, UN Habitat, and Medici Land Governance have funded many land title registration programs around Africa. Consider Ghana, where unregistered land is usually equated to squatter settlements and slums. But as shown in figure 3.1, customary land, about 78% of all land in Ghana, is also largely unregistered. Unregistered land is not only about informal settlements, it is also the basis of the informal economy, estimated to be more than 50% in many cities in Ghana. This informal economy is also the heart of the creative economy, the lungs of the circular economy, an innovative and integral part of the social economy. There is no sharp distinction between use and exchange value in this economy. Use value has exchange value, and exchange value has use value. Insights that can be found in the work of economic anthropologists such as Karl Polanyi and Keith Hart. Unregistered land embodies property in both labor and land, both use and exchange value, both physical and economic space. Researching unregistered land required 3 iterative steps, carefully examining valuation reports prepared by valuers or passed by the Ghana Institution of Surveyors, studying relevant Ghanaian court cases, and interviewing valuers. Our 4 findings are detailed in the RICS report, Valuing Unregistered Land. But briefly, we found that valuers have adapted existing valuation methods to value unregistered land, often deducting the cost of registration from capital or compensation value. Decided cases like the Bannerman Hall case show that under Ghanaian law, regardless of the length of time for squatting or even the acceptance of payment from squatters, squatting does not ripen into a right to compensation. International agencies, on the other hand, insist that even squatters should be paid some compensation, but mainly to mitigate project risk. The courts uphold these innovations, especially if they are reasonable, and in the majority of cases recognize the legality and value of unregistered land. Problems of undervaluation recur, but they arise not so much from non-registration of land, but from ahistorical top-down valuation practices, from the limited engagement of the social context of value, from little involvement of victims in the compulsory acquisition process. These findings are from Ghana, but our report shows that they are found elsewhere too. Compulsory acquisition is a well-known state mechanism to pursue the public good, a point often made in modern methods of valuation. While President Trump considers the South African Expropriation Act 2024 is meant to, quote, seize ethnic minority Afrikaners' agricultural property without compensation, unquote, the act, in fact, aims to lay down the rules for compulsory acquisition in the public interest with just compensation. While public interest includes correcting racial maldistribution of land, in which Black South Africans constituting 81% of the nation's population own only 4% of land, it is only if land has been abandoned or land is the scheme of ongoing speculation, hoarding, or under investment where no compensation will be paid. Appeals for landlords to voluntarily sell their land in free markets has undermined the public good. As the book Land Matters, South Africa's Failed Land Reform and the Road Ahead shows, white landlords have typically refused to sell land to Black people particularly black women. The question then is how to develop reasonable value that is just and equitable for compulsory acquisition purposes. Valuers can adopt a more historical approach, bearing in mind the often unacknowledged creative economy and other contributions made by ordinary urban residents to unregistered land in the urban economy. Technology can assist too, engaging archives, assessing case law, communicating with victims, analyzing the value of unregistered land through data analytics. Rethinking just compensation must entail considering our craft as part of the global development process, probing whether so-called squatters might in fact be autochthonous. Professional bodies can develop such standards about and strive to enforce this historically informed participatory valuation, both nationally and internationally. This would call for a bit more creativity and curiosity, but that is in our history. In his book, Ground Under Our Feet, R.T. Ely, the founder of land economics, urged land economists to look and see, in quotes, his way of stressing the importance of historical methods of valuation. This could be more difficult but rewarding, with valuation expanding from an art, as Justice Jacob called it, to valuation as a social science. This is echoed and emphasized by, quote, integrating technology, embracing creative economy, and upholding social responsibility in compulsory acquisition, unquote, the theme of our conference. Thank you very much.
Thanks, Franklin. Shall we continue the discussions, or we're going to have coffee break? I think in the agenda, we're supposed to have the coffee break after this presentation. Continue. Okay, excellent. So then we're going to continue discussion and then ask a couple of questions to the presenters. So maybe I can start with Ben, since he started, he's the first presenter. Ben, are you there?
Presentations, thank you.
Hi, Ben. So my question to you is, as you say, market is not good at revealing non-use values, and many of the social values are non-use values. And it's interesting you propose the stated preference methods, like the willingness to pay, maybe the way to go, the good method to use in assessing the non-use values. But then the practical question is how to ensure fairness to all, especially because in the context of public investment, compensation is paid from taxpayers' money. And so we should not only think about the fairness to the affected people, but also the fairness to the entire citizens, taxpayers. How to ensure the fairness to all as you possibly use stated preference methods in evaluating assessing the non-use values?
Yes, nice easy question to start with, Satoshi. Thank you. That's a great question. I mean, it's almost impossible to ensure fairness to everyone. But I would go back to my statement in my presentation that valuers need to have the instructions. They need to understand what it is they are being asked to assess. And that fairness is the role of the politician and the organizations rather than just the valuer. The valuer can capture the information, they can explain how they've approached it and the information they've used, and they come to their opinion as valuers. That's their role as that professional. But that number might change depending on the policy. So, for example, we know that in certain countries, the compensation which is paid for land which is acquired is inflated by a percentage. So in India, if you have rural land which is acquired, and I'm going from memory now, I think they pay 115% of the market value to capture that part, and that's considered fair both to the taxpayer and to the recipient. And if it's in urban areas, it's a slightly different percentage. Again, if I remember correctly, I'd say it's 110%. But that's a policy which is trying to capture that fairness. If you go down to trying to be fair and equitable to every individual, that's almost an impossible process, Satoshi, and would almost prohibit the implementation of the plans. And assuming if it's an infrastructure project, there are benefits which will flow from that infrastructure project, as well as what you might take on a micro scale. So all those issues are around fairness. The valuer's job is to interpret the instructions which they are given. And it gets very dangerous if the valuer starts to make policy. I think I've explained before that I was involved in a project at one stage where the valuers were actually trying to be fair to the people who were being displaced from the land, and they were doing that by counting the number of children and trying to work out a displacement process. It was in a community which was affected by AIDS, and the land was going back to the chief, and then being the individuals were trying to get some compensation. But then you sort of try to work out, what do you mean by a child? Is that what happens if there are different siblings? And the valuer is left with this impossible task of being fair, whereas the valuer is good at interpreting the economic facts which are in front of them. So I don't know whether that helps, Satoshi, or not.
Thank you very much. We discussed a lot in the past about this, market value being the triggering point, for instance, that allows a negotiation to start. So in that context, yes, that you can estimate the non-use values in any way to allow the affected people and project proponent to negotiate and get to an agreement. Yeah, it's a very interesting point. And in a way, this answers the question raised in the previous sessions about the role of the valuers. Yeah, I think I fully understand the valuers, the profession of the valuers is valuation, property valuation. And then they should not, or they cannot get into the business of what are the social impacts, what are the non-use values and things. But I think the valuers can contribute to these discussions by estimating the new non-use values and allow the negotiation to start. Yeah, I think that's a fair point. So moving on, Nick. So your point, discussion of the native rights, very interesting. My question is, who actually determines the scope of the bundle of rights of the native titles? First Nation groups freely determine the scope of, the bundle of rights that there exist in their own territories, and if so, or regardless, I think they have to have the legal personality. And that the geographic areas of the territories, their territories need to be officially recognized. These are the two preconditions for the native rights to be used in the native indigenous land use agreement, for instance. So this is an important issue that is very largely debated in Indonesia right now. So can you elaborate a little bit on your Australian experience?
Yeah, so can people hear me? Is this on? Yeah. It's a really good question, and it's a really interesting issue. In Australia, the way that is established is that the Aboriginal group in question will claim the rights that they claim are their rights. So they will often have an anthropologist expert or other experts in addition to evidence that they'll put forward showing that they have traditionally used certain rights in the land since Europeans came to Australia. And then that process goes to court, where there was a very long period of resolving these claims, went for 25 years. That was not just the government and the Aboriginal groups, mind you, who were disputing various claims. There was an overlap between different Aboriginal groups. You had multiple different Indigenous groups who were claiming the same area, and these issues needed to be resolved, and that was quite complex, and remains complex. There are people today who are still upset by the outcome of some of those resolutions. They don't agree with them and so forth. And I understand that. Largely the system required lines to be drawn on maps, which in some ways didn't have those lines historically. It's often said it's one of those great diseases of Europeans to draw lines on maps, and this was part of the native title system did that as well. One thing Australia did do, though, which I think was very good and I think does deserve some recognition on an international format, was that if a claim was put forward by an Indigenous group that they had native title, it went through a preliminary test that was not too stringent. If the report stacked up, that group got what they called the right to negotiate whilst the claim was on foot in the court. So they got preemptive rights to protect their interests while the court was resolving the native title claim. And so it wasn't that they had to wait 20 years before they could do something. If their claim was past certain threshold, like if it was sort of bona fide relevant and past a certain standard, then they were immediately afforded those rights, often for 15 years while they were resolving their claim with the government. And so that did make a big difference. There were a number of things which happened in that period. Now, obviously, in a practical sense, the Indigenous group is at a significant disadvantage before it's resolved its issue. I recognise that, and I think everybody recognises that. But it's definitely better than a situation where they would have had to wait for 15 years to be recognised before they could even exercise any rights. So there was, and there remains in Australia, a system that if a claim goes in, as long as it hits certain primary, what we call sort of prima facie, sort of first look conditions, which are not too strong in Australia. It's really just a valid report and a valid authorisation. Then the protections come into place in many respects immediately. After the claim is resolved, and it can be resolved in one or two ways. It can be resolved either by agreement with the government in the court, and they make consent orders. In Australia, we have a very strong separation between court and executive government. It's not always consistent around the world, but in Australia, that's how we operate. It can either be done by agreement, or they can have a trial where the judge will adjudicate all the evidence and make a ruling. And that ruling can be successful or unsuccessful. Most of the time in Australia it's resolved by agreement nowadays, but there have been examples of there being big trials. When they're resolved, the law requires that there be a corporate entity. It's a specific corporation. It's not a corporation that non-Aboriginal people can be a member of. It's what's called an Aboriginal corporation. Requires that be set up, and it also requires that anybody who's a native title holder must be able to join that corporation. They can't be excluded. And the court will make a ruling as to who the native title holders are, and it will normally do it through applying 3 tests. And the first test is that they must be descendant of certain people who are defined as the apical ancestors, that they must have a connection to the area of the determination. That can sometimes have certain requirements, what a connection means, but normally it's left to be relatively broad, and that they must identify as a member of the group, because obviously people can self-identify not to be a member of a native title group, especially if they've got dual ancestry. And then any one of those persons is eligible to be a member of the corporation. Like all these situations, there are corporations which are run very well, and there are corporations which are not run as well. There are corporations which are well resourced, and there are corporations which are poorly resourced. So I don't want to come here from an Australian point of view and say the system works perfectly, because it doesn't. There are terrible examples in Australia of it not working, and corporations being completely rolled over by corporate interests or being mismanaged themselves. These are problems. But there are also, to be clear, neither extreme is true. There are also very good corporations out there doing very good work. It's easy to fall into either narrative, and neither narrative. They're not all bad. They're not all good. But there are some excellent Aboriginal corporations out there doing phenomenal work. Many of them doing the work of maybe 10 or 15 of our regional municipal councils with half the resources because of the area they cover. You know, I think of one group we've done a lot of work with called the Bungala native title holders. They have 15 councils, they have maybe 500,000 people living in their area, and they manage developments throughout their entire country with only 3 or 4 staff and almost no government funding, yet they're on top of everything they do, and they're very efficient. Other corporations are not so fortunate. But yes, there is a requirement for that, and that's the structure we've created. Because one of the biggest problems when we're dealing with unregistered interests owned by communities is that you obviously have to have some structure around it. The final point I might make to that, if I can, is that in Australia the law requires there be a community vote if there's any agreement to remove any community property. So we have it's under legislation. It's binding on the Aboriginal groups and on the corporations. And so if there's going to be some kind of agreement for a development and someone needs what we call native title approval in Australia, then there must be a public vote where any member of the community, whether they're a member of the corporation or not. So if you've got someone who's not a member of the corporation, they never joined, but they are a native title holder, they're entitled to go to those meetings. And that system's in place, and there must be a majority vote. Or if there's a traditional system of law and customs that the court has acknowledged where there might be elders who get a more dominant say or something like that, then that system will be applied. But generally speaking, most of these decisions are made by majority vote. So that's the system we have. And in some ways it works surprisingly well, acknowledging that there are significant flaws with it.
Yeah, thank you very much. It's very interesting, especially in Indonesia. You mentioned during the presentation, masyarakat hukum adat. This functions, the legal recognition exists, but it takes really many years to get this recognition. At the BPN, launched a regulation last year or 2 years ago that allows the recognition of land rights without the prerequisite. I mean, the MHA recognition as a prerequisite. That's an important step forward, but this legal recognition thing is very challenging issue. Yeah. So Franklin, so you're talking about this just and fairness and compensations. Very fair, very agree. And this is what the World Bank and other international financing institutions aspire for. But challenge is particularly on intangibles, some social values, non-use values. How to determine that? How to estimate assess such non-use values or social values? Yeah. In your experience, and based on your knowledge, like as Ben said, that this kind of surveys maybe an approach to go, but it would be interesting to hear from you and elaborate your experience on this matter.
Theory and practice are not opposed to each other. I say they are not necessarily opposed to each other, but they are not necessarily the same either. In theory, land economists in Ghana are educated or trained to assess intangibles. Courses such as statutory valuation, advanced valuation, theories of land values, will treat such subjects. Indeed, the standard test used to educate land economists called modern methods of valuation treats the question of intangibles, but that is in theory. In practice, our study of valuation reports, both those ones prepared by certified valuers and those that have been passed by the Ghana Institution of Surveyors, do not necessarily go into these complexities. If they do, then it's because one of these international organizations or multilateral banks have suggested so, and they have a stake in the project for which the valuation is undertaken. It is possible that through a more consultative, a more participatory valuation process, more of these intangibles could be included in the valuation process, given that, at least in terms of education and training, these land economists who eventually become valuers have got the basic or core or fundamental education or training to value intangibles. And hence, the position I take in the talk and in the position we take in our report, that it is crucial to make valuation a bit more consultative, a bit more participatory, and a bit more a social practice than a technical exercise.
Yeah, that's very important element. You know, on the one hand, I hear in many of the projects in Africa, including some World Bank funded projects, compensation is paid to the ethnic group. And then maybe the clan leaders receive the money, decide how to use the money, or distribute the money. Then it's questionable if the people who are seriously affected by the project, maybe needing to resettle others, got the fair compensation, as opposed to people who lose only a little bit of impact. So it's this inclusiveness to make sure everybody participates in the discussion of the impact and make sure people get the fair share of the compensation is very important. Do you have any concrete examples of such inclusive evaluation of impact?
In practice, the land economists who eventually become valuers, they consider themselves more as experts or technical valuers. And so that is not the typical standard. Yeah, in theory, we could discuss it. We can discuss it in the classroom and in social settings. But those cases that have made it to the courts, those cases that we have studied as represented in valuation reports, they aren't participatory. Yeah. They are reports written by specialists. Full stop. Yeah.
Yeah, especially if you think about intra-household differences, like female members, you know, the male head of the household, particularly in the polygamy family communities. It's a lot of differences and complexities about the distribution of impacts and fair share of the compensations. Okay, maybe we can open the floor and receive some questions from the participants on the floor. Please, okay, yeah, a few hands I already see. Please come around and then get the microphone. State your name and ask your questions or provide comments. Please use the microphone over there. Yes, after him, yes.
Okay, thank you for the question. And my name is Fian. I'm failure from Indonesia. So regarding the question is, wait, let me check. Okay, so we understand that Indonesia we are currently using our own standard for valuing for land compensation, right? But what we are talking is about the unregistered land. I think this is still a gray area. So we have heard from the speaker about the method, the approach that we could use. But my question is regarding the deliverables that we as valuers could submit to the client or to any stakeholder that need this value. So based on many cases, which I understand, is if you're talking about the unregistered land and especially customary land, the case by case, even in Indonesia, it could be different because there's so many ethnicity, there's so many special cases, and when we talk about the approach, it could be different between one culture to another, especially. So maybe if the result itself, we as a valuer usually present our deliverables in monetary value. That's the main idea. We use the market value as the basis, and in Indonesia case, we add several additional value, let's say. But in case where the value itself, first, it's not in singular monetary value, or it might be compensated at any other form, or even the deliverables, it will be unreasonable if we term it in terms of a monetary value. How do we as valuer approach this as valuer? Because we already have our standard. I think we have been here, focus in IVS, right? So it really strict to the standard. We produce the value, but if we talk about unregistered and social value, it could be in various form. So how do we as valuers approach this as our profession in our market practice? I think that's the issue that I would like to put to the floor. Thank you.
Thank you very much. Who want to take it? Ben, yeah, I thought so. Ben.
Yeah. Great. Okay. Yeah. Thank you. Yeah. Again, a really great question, Fian. Great to see you again. The challenge around that is to be able to deal with the comparable evidence in a structured way. And I'm going to make it sound very simple now, and I appreciate it's not simple. But even if we're doing a traditional valuation of registered land or an asset which is registered in a cadastral system, there are all sorts of different deals that get done and get recorded in legal documents. Not all leases are the same. They're different lengths. They have different requirements. And I've very often said that value isn't held in land or buildings. It's actually held in the right to use the land or the buildings. And in registered properties, that's probably a lease or a freehold document. And those contain myriads of different requirements and different responsibilities on both the occupier and the owner of the land. And it may be tiered in several layers of ownership, which makes it really complex. But the valuer's job is to capture that data, to get that data together and analyze it, and be able to say that they've increased it or reduced it by 5% because the lease that they were looking at was for a larger piece of land than the one that's under question, or the lease was for a longer period of time. That's the skill of the valuer. And I would say the same applies to the investigations which sit around different cultural approaches. Valuer's job is not easy. It's never been easy. But we are skilled at looking at those particular areas. And again, going back to the International Valuation Standards and the RICS Red Book, you shouldn't act outside of your area of expertise. So if you've never done a valuation of this type of unregistered land, you need to be able to demonstrate how you've got the skills and how you've learned to be able to approach the project. So, and again, going back to the challenge of being a valuer, where our skill set is often, or traditionally was, a mixture of art and science. In the registered world, we're becoming more science than art, but I would argue that in unregistered markets, we're still very much in the art area, and we need to be able to explain that art to all parties in our reports. And again, some of you have heard me speak before that I quite often, when I used to lecture at the university, I used to tell students that it was being a valuer was like being Sherlock Holmes. You had to go out into the marketplace, you had to uncover evidence which you then used to establish your case, and some of that evidence may have to stand up in a court of law. So it needs to be verified, and that is not an easy job, but being able to record and reiterate how you've come to your opinion, because value is an opinion, it's not a fact, it's an opinion, but being able to explain that story of putting that process together, and that's why I said in my presentation, valuation is a process. You go through each step, and you need, as being the valuer, to be able to explain how you've approached each step of the story to completion. Valuers are great at making those assumptions. I hope that helps, Fina, and thank you for the question.
Thank you.
I just thought there was something I'd add to Ben. What Ben said, valuation is you're valuing the rights in the land, or the rights to use the land, not the land itself, whether that right exists in a lease or other form of tenure. And I know that's the Australian experience we've had when we've tried to value unregistered interests. What we've tried to do is we've tried to take what those unregistered interests are and create as best we can a parallel to the rights to use the land in that unregistered interest, and then determine the value from that metric. And that's, again, that ignores some of the intangibles, but the methodology has been to try and look at it from rights in land. That's and then try to say, well, there's activities happening on the land. Let's imagine those activities as if they're a bundle of rights. The bundle of rights is a little bit of an artificial construct in the Australian native title system. I don't think Aboriginal people tend to think of it as a bundle of rights. They tend to think of it as a cultural obligation to the land. But we have translated it that way as the Australian legal system, and then that allows us to value it as if it's rights, and that's the extrapolation we do at a core level. It doesn't solve the intangible, the utility, the salation, the cultural dynamic, but it does give a foundation, which I just wanted to add to Ben's analysis, because I thought how he said that was very useful.
Thanks, Nick. And if I may just add a little bit, additional issues. The question of commons, common resources like the forest, where people collect timber, non-timber forest products, or some medicinal herbs and others, it's very difficult to separate who actually have the fair share of compensation individually. So for typical World Bank project, we often establish community development funds based on some estimation of the values that community get from the common resources as the community, and let the communities manage these funds, so that they can continue to have some access to ways to benefit them So it's the common natural resource is a very challenging area to establish. Estimating the value of the common natural resource is probably easier, but then who gets what share of it is very difficult and challenging.
I just want to say that Fabien's point is that the world is not flat. He's very right. In fact, he's very, very right. And he illustrated his point using the Indonesian example. I just want to quickly add a Ghanaian side to it, and also a Peruvian side to it, and then conclude with what I have been suggesting as a possible way out. In Ghana, squatter settlements would fall under unregistered land, and so squatters will have no legal basis for compensation. But in Peru, squatters who have been in possession of land for a continuous period of 10 years could claim ownership. In fact, in Peru, valuers also don't get involved in the valuation of unregistered land at all. But once squatters, for example, obtain ownership through squatting and through some acquiescence, in the sense that the possession is not disturbed for that period of 10 years, then valuers then get involved in the process of valuing. The point is this: the differences can be quite huge, and so one way of going about this complex process is not simply to say that, oh, this is so complex, but to acknowledge that no one valuer can address these complexities, and therefore considering valuation as a social process or a social practice is quite a useful way of arriving at a just and equitable compensation value.
Thank you very much. Other questions? I saw a few other hands.
Thank you, Pak Ishara. Hello, Ben. How are you? I think this issue is already discussed several times in Brunei, Vietnam, Cambodia, and Singapore. I saw your presentation. There's exposure draft. Nah, I want to know when you plan to be definitive, because the other country, as the member of International Valuation Standard Committee, waiting for the definitive standard, because the other countries must be comply to the IVS. So, because we're waiting for it. Thank you.
Ben, I think this is a points made to you. I think you're muted.
I should know by now. Great to see everybody there. That's fantastic. International Valuation Standards had an exposure draft last year. They're working on it at the moment. As I understand it, there will be a consultation on a draft next year. But Alexandra Aronson's the person to be able to ask that question to from the IVSC. Although, of course, Nicholas is there, so Nicholas can probably answer that question about the update to the International Valuation Standards better than I can now, because I've stepped down from the Standards Board. But my understanding is they're working on the update, and that will go for public consultation in the new year. I think.
Nicholas, you want to add?
Hi, Ben. It's great
Hi.
to see. Well,
How
it's
you
me
doing?
again. In case
Yeah, you're
case
good.
you. Yeah. Ben is having withdrawal symptoms from not being at the IVSC anymore, and yet he's there. He's checked out but never leaves. It's like Hotel California. But he's absolutely right. We are currently working with our board members on a new version of the IVS. We're doing significant improvements and upgrades. It's important to note that we had an agenda consultation just a few months ago. It attracted a record number of responses from all over the world, including from Asia. In fact, the largest contingent of responses was in Asia. And so this participative movement is really taking hold. And so this will feed into the deliberations of the boards, and the boards will issue an exposure draft early 2026. That you will be able and invited to comment, and the effective date will be 31st of January 2028. So we're already working on a new version, and I know that in particular when it comes to the tangible assets, there are certain new developments that I think everyone will find very, very interesting. So thanks again, Ben.
Thanks, Nicholas, for additional clarifications.
Great to see you, Nicholas.
And I saw a gentleman over there raise hand before, but I don't see him. Maybe he stepped out. Otherwise, Zara?
Thank you, colleagues, for a very interesting session. And hello, Ben. Nice to see you, although online. One observation from representative of Asian Development Bank and representative from multilateral development banks in general. We do not use the term in the policies unregistered land, but we do consider the rights that are not registered. And there are two types of approaches how we approach. If the rights cannot be registered at all under the legal framework of the country, then those are considered, that land use is considered as non-titled, and we have separate way to approach how to compensate the livelihoods and losses of that people. But if rights could be registered, and going back to the question that Franklin asked at the beginning of his presentation, should we register to value? Now, according to MDB's policies, and it's not only ADB's policy, but also of the World Bank, if it's possible to register under the country's legislation, we are just considering it as a titled land. So people are compensated based on replacement cost in a way that we would compensate the titled owners. Just a remark and observation for those who may work on the project financed by the multilateral development banks. Thank you, and thank you again for the presentations, Frank, Nick, Ben, and Satoshi.
Question? the question, I mean, it's not really a question, I guess.
I thought it was a comment.
I would say in the Australian context, we probably don't use unregistered as a term either to define native title. We would look at it as a property right, which is not within the framework of our torrents title system, but we would still see it as a core property right. In fact, it was just pointed out to me there was a High Court decision recently, and the exact point of that High Court decision in Australia was to reaffirm that there is, from a property perspective, no difference between native title and any other form of property. It's just recorded in a different format in Australia. So I agree that there can be a danger in labels if people believe that the interest is subsidiary because of the label. I suppose as a lawyer I work in labels, it's an occupational hazard. So no, the comment's useful, thank you.
I just add, okay. If I add, the World Bank and ADB policy is true, recognize, I mean, includes those who have recognizable rights. And this recognizability is a tricky area, but gives a lot of opportunities. Like in Indonesia, Kotaku project, I think in Semarang, the government went a very long way to identify what recognizable rights people may have to make sure people benefit from the slum upgrading project. So as a result of the many years of efforts, most of the slum dwellers got the recognition to join the project and then benefit from the slum upgrading project. So this issue, concept of recognizability, is something that we can really exploit more actively. Yes, absolutely. This is what I did a few years ago. Any other questions or comments? Yeah, I know. If not, then yes, time is running up. So thank you very much for the panelists, as well as the nice discussions. Thank you very much.